Interstate River Water Disputes Amendment Bill 2017 can be the stronger river referee. Do you think Interstate River Water Disputes Amendment Bill 2017 facilitates the speedy resolution of disputes? Should water be placed in concurrent list? GS Paper 2, Indian Polity, Interstate Relations. What is the context about? In the last session of Parliament, the government introduced the long-awaited Interstate River Water Disputes Amendment Bill 2017 and called it a revolutionary step towards disputes resolution. The bill does have much that will tighten the adjudication of river water disputes. But will it lead to speedy resolution of such disputes? The Supreme Court and other courts do not have jurisdiction over such disputes, but they can interpret verdicts of tribunals. Do you think Interstate River Water Disputes Amendment Bill 2017 facilitates the speedy resolution of disputes? The bill proposes a permanent Interstate River Water Disputes Tribunal, ISRWDT. In the current arrangement, tribunals are formed when a river water dispute rises. These are dispute-specific. Each dispute will be referred to a 3-member bench and resolution will be time-bound. These measures can improve the efficiency of disputes adjudication. The bill provides for a DRC, Disputes Resolution Committee, to enable ex-ante negotiated settlements, in place of earlier mediation by the centre. This is an interesting provision, evidently to avoid disputes advancing to the next stage of legal adjudication. But its benefits will depend on the mechanism's efficiency. The new bill allows the centre to appoint or authorize an agency for the purpose of data bank and information system, perhaps to draw on the existing capacities of the institution. This arrangement could hit a roadblock given the tenuous centre-state relations over managing river waters. As per bill, the entire process of dispute resolution will be completed within a time span of 5.5 years after considering all possible extension. And thus it will provide speedy resolution. Should water be placed in concurrent list? Water as a subject is larger than rivers, ponds and lakes, springs, groundwater aquifers, glaciers, soil and atmospheric moisture, wetlands, and so on, are all forms of water and constitute a hydrological unity. Hence, keeping the environmental, ecological, social, human, and rights concerns relating to water, it seems necessary to place this subject under the concurrent list. In the recent past, there have been serious concerns relating to groundwater, rapid depletion of aquifers in many parts of the country, the emergence of arsenic and fluoride in many states, etc. It is also interesting to note that there is no explicit reference to groundwater or aquifers in the Constitution. Hence, in this context, some experts want the subject to be moved to the concurrent list. The sense of water scarcity and crisis now looms large. It is clear that while action will be called for at the state and local levels, the perception of a crisis casts a great responsibility on the centre. National initiatives will definitely be called for. Finally, it appears that to the Constitution may cause water meant essentially river waters and irrigation. In that context, it might have appeared appropriate to assign the primary role to the states, and provide a specific role for the centre in relation to interstate rivers. But, since most of our important rivers are in fact interstate, and interstate river water disputes are on rise, it is argued that the centre should assume a greater role.